The part of that lecture that was supposed to start last week, in particular on extradition without a treaty, why was it especially important to understand what happens when there are no specific or bilateral international treaties? So, the primary issue is that of the process of extradition without a treaty between law, custom, reciprocity, and above all, legal pragmatism in practice. At that time, in short, if you turn to, for example, let us say, at first glance, especially to a jurist or in any case, to a lawyer or a judge, the seemingly apparent premise for operating in the extradition field is that precisely because it is apparent of the apparent irreplaceability of the treaty. In particular, this perception is often held by those in the legal profession. In the context of international judicial cooperation, extradition, as you probably already know, has traditionally been considered a specific form of treaty based mutual legal assistance. And it is a widespread and commonly held belief even today. It is a well established academic principle that, in the absence of a formal bilateral or multilateral treaty, there is a fundamental barrier that effectively precludes the possibility of a legal handover of the individual from one state to another state. However, the gradual and ongoing evolution of international practice, as well as the progressive consolidation and strengthening of the criteria of reciprocity, therefore, aside from the emergency situations that may arise, and also taking into account the supranational needs and requirements of criminal justice, have profoundly and significantly modified this traditional approach. That is, an approach that, in the past, considered the existence of a treaty to be absolutely irreplaceable and indispensable. In order to do so, it is traditional. The question we must ask ourselves as legal scholars and practitioners is whether it is, in fact, legally admissible to proceed in this manner, given the current state of international law and the evolving landscape of legal cooperation between states. An extradition, even in the absence of a conventional agreement. The answer, and I'll tell you right away so we can break things up. Any delay is, yes, legally permissible. An extradition, even in the absence of a conventional agreement, however, is not always possible in certain circumstances and only in compliance with some fundamental principles. Yes, we can indeed affirm that extradition can, in fact, take place even without a contractual basis. Formal. Let's talk about the voluntary nature of extradition. So we must start from a cardinal principle, right? Extradition is not the customary obligation between states, and it requires the consent of the requested state. This consent can derive precisely from a bilateral or multilateral international treaty. It can derive for certain countries from domestic law, or even, and pay close attention here, from a unilateral declaration or an established practice of cooperation, that is reciprocity. Um, Now, I don't know if there are people here around my age, but you may well remember that, for example, Santo Domingo, that is the Dominican Republic, has now established a proper extradition treaty. But how many times, in the absence of a treaty, did Santo Domingo? I say Santo Domingo colloquially because that's what people say. Santo Domingo is actually the capital, but everyone calls the Dominican Republic Santo Domingo. So let's just say DR. How many times in the 80s and 90s did the Dominican Republic decide whether or not to extradite a person based on the principle of reciprocity? So it's very important that you keep this in mind, especially in international classic. In law, extradition is always regarded as an act of sovereignty. The state is therefore free to grant extradition or to deny it according to its own discretion. This margin of discretion opens up the possibility in line, both in theory and in practice, of proceeding with an extradition even in the absence of a specific treaty. We are talking, in fact, about the legal foundation of today's discussion, which is reciprocity. In legal doctrine, we speak of formal or diplomatic reciprocity. That is in many legal systems, including the Italian one. And I also invite you to look through our Code of Criminal Procedure. If I'm not mistaken, it's Article 697. The law provides that extradition can occur by virtue of reciprocity, even in the absence of a treaty. So, what can reciprocity consist of? It can be a mutual diplomatic commitment between the two states, so a specific diplomatic agreement, signed ad hoc, a verbal note exchange between the central authorities, and at the very least, in the absence of an express form, in de facto reciprocity, which is substantiated by previous cooperation in similar or identical cases. So remember, a diplomatic commitment, so an ad hoc diplomatic agreement, verbal notes between, let's say, the top authorities, and then de facto reciprocity. So be careful because de facto reciprocity, even though it represents, let's say, the last and least, the least important of the options, it opens up a truly incredible scenario. This is why it's important to take a look at Italian case law on the subject of de facto reciprocity. The Italian Court of Cassation has clearly and explicitly recognized the legal validity of extradition, even in the absence of a formal treaty, as long as a well established bilateral or multilateral practice can be clearly identified. So it must be identifiable. There must be this identifiable bilateral or multilateral practice, and this practice must be well established. Here you see we are getting closer, right, to the concept of a principle derived from customary law. In particular, I've jotted down this cassation ruling because I would never remember it, but it's one of the foundations, one of the pillars. That is the ruling 32,178 of 2019 is a landmark ruling issued by the sixth section. What does the sixth section tell us? It tells us that in the absence of a bilateral treaty, extradition can be granted, and I'm reading verbatim, on the basis of the principle of reciprocity, even if presumed or de facto. So, the Court of Cassation. This section introduces the relevant parameter as well as the terms of the presumption when there are no barriers of a constitutional or conventional nature present. Therefore, de facto reciprocity can only be blocked by the limitation, by the impediment arising from a fundamental article of the Constitution or from other international conventions, or by other international conventions, which, as you know, have the force of law, constitutional law of the state within the hierarchy of sources of Italian law. So, reciprocity can generally be reasonably presumed based on precedents, diplomatic practices, or even conclusive acts. The review of all this obviously falls, as is logical, to the Court of Appeal. The Court of Appeal is responsible for assessing the legal admissibility, and then the Minister of Justice carries out a second review because it is specifically at the Ministry of Justice that the final and ultimate political decision is made regarding the extradition process itself. Therefore, what is the role of domestic law? When national law permits or authorizes it, in practice, many legal systems allow extradition without a treaty basis. They generally allow it if domestic law specifically permits it and if there are no impeding or prohibitive causes, such as, for example, the existence of the death penalty, political crimes, acts of torture, the nationality of the foreigner, and so on and so forth. In the context of Italian law, Article 697 specifically establishes the legal framework for the possibility of granting extradition, even in the absence of a convention, if there is a guarantee of reciprocity. In other countries, like the United States of America, the Department of Justice can evaluate on a case by case basis even outside of treaties. And let's say, for example, in particular in the United States of America, the discretion of the executive branch takes on a preeminent value, as does the concrete arm, characterized by the diplomatic channel, which serves as a formal means of communication. Let's now turn to what is the subsidiary use of the UN conventions. So Palermo, Merida, all those we have cited and recited 1,000 times. When specific extradition treaties are lacking, some sectoral conventions can provide an alternative legal basis. Okay. So, for example, the UN Convention Against Transnational Organized Crime from Palermo, the one made in Palermo, signed in Palermo in 2000, the UN Convention Against Corruption of Merida in Mexico, Article 44 in particular, and the Convention Against Terrorism. In other words, these are various sectoral conventions. In such cases, the conventions can be invoked as a basis for extradition, even if the states have not entered into a bilateral treaty. Now, moving on to the constitutional and conventional limits, let us briefly discuss them. Of course, extradition without a treaty is not. We can say it's neither automatic nor unlimited, but it must respect the fundamental rights of the person, the principles of the ECHR, in particular Article 3 on torture, Article 6 on a fair trial, and Article 8 on private life, and so on, of the citizen or even of the individual. Of course, constitutional principles come into play. For example, in Italy, Article 26 prohibits extradition for political offenses, except for international obligations. We talked about this, I believe, in the first or second lesson, and the principle of specialty also applies and carries considerable weight. That is, the prohibition for the requesting state to prosecute for offenses different from those stated in the extradition request or the Interpol warrant. So the principle of specialty must always be guaranteed even without a treaty out of respect for the principle of legality. So you understand that since the power to base an extradition on various elements is so extensive and wide ranging, the scope for defense becomes equally very broad, meaning that one can effectively identify which principles, such as ethical guidelines or core values, to adhere to or be guided by in a particular context, making thoughtful choices about which standards are most appropriate to follow for the assessment of the specific case. So one can really work with a broad spectrum of sources. The ECHR, that is its principles, the Constitution, the conventions, and in any case, all the pacts to which Italy is a contracting party. So the conclusion is what I mentioned at the beginning. Extradition is possible even without a treaty. In light of what has been said, it can be concluded that extradition between two states is legally admissible, even in the absence of a bilateral or multilateral treaty, provided there is a basis of formal, also called diplomatic or de facto reciprocity, that the domestic legal system of the requested state allows it. We have a rule that allows it, and if the principles of international law are respected. This possibility, mind you, is not an ordinary one, so much so that many courts of appeal sometimes don't even consider it. It is extraordinary. However, it still remains a fundamental tool for the effective suppression of transnational crimes, especially in an era like ours, which is characterized by very strong global mobility, by financial crime, and also by so called strategic absconding.